The US government just made 7 major immigration announcements in a single week, and I am not exaggerating when I say that some of these changes are going to affect you directly, whether you are on an H-1B, an F-1, a K-1, a work permit, or waiting for a green card. We are talking about social media screening just expanded to brand new visa categories starting this week, a proposed rule that would raise H-1B wages by 30%, a wave of denials hitting applicants who thought they had an exemption to a $100,000 visa fee, and a visa bond program that just added 12 more countries to its list. These are not rumors. These are not predictions. These are official announcements from the State Department, from uscis, from the Department of Labor that came out in the last 7 days. I have been tracking every single one of them. I have gone through the official notices, the legal analysis, and the attorney advisories. And in the next 15 minutes, I'm going to break all of it down for you in plain English, so that you know exactly how each change might affect you and exactly what you should do right now. This is your immigration news briefing for the week of March 30th, 2026. Let us get into it. The government is now reading your social media, and they just added more visa categories. Let us start with the news that is going to affect the most people: the social media screening expansion. Effective March 30th, 2026, and which is literally this week, the U.S. Department of State has expanded its online presence review to a new set of non-immigrant visa categories. The categories now added to social media screening include K-1 fiancé visas, religious worker visas, trainees, domestic workers, and humanitarian categories, including T visas and U visas. These are joining categories that were already subject to screening: F1 students, M1 vocational students, J1 exchange visitors, H1B workers, and H-4 dependents. So what does this actually mean? It means that if you are applying for a U.S. visa in any of these categories, a consular officer will now review your online presence as part of your application. Your Instagram, your Twitter or X, your LinkedIn, your Facebook, your TikTok, whatever social media accounts you have publicly visible, they are part of your visa file. Applicants are required to make their social media accounts public during the adjudication process. If you have private accounts, you need to understand this requirement. Now, here's something important that I want you to understand. The State Department has not published a detailed rubric of what content will trigger further review. They have not told us exactly what a consular officer is looking for when they scroll through your posts. What we do know from immigration attorneys who are advising clients right now is this: anything that is inconsistent with your stated visa purpose, anything that raises questions about your intentions, your background, or your compliance with immigration law can and will be used against you. What does that mean practically? If you are applying for a K-1 fiancé visa, but your social media suggests the relationship is not genuine, that is a problem. If you are a religious worker, but your online presence does not align with your claimed role, that is a problem. If you're on any visa and your posts, photos, or associations raise national security flags, that is a problem. Immigration attorneys are strongly advising all clients right now, before any visa interview, before any application, to do a thorough audit of their public social media presence. Go through your accounts. Review everything that is publicly visible. Think about whether anything you have posted could be misread or taken out of context by someone who does not know you. This is not about hiding anything. It is about being prepared. Your digital footprint is now part of your immigration file. That is the new reality. And the processing impact is real too. When H-1B screening first expanded, consulates in India started rescheduling December 2025 appointments out to March and April 2026 to accommodate the additional review time. Expect similar delays to ripple through the newly affected categories. The $100,000 H-1B fee. Exemption requests are being denied en masse. This next story is one that is causing serious alarm right now among immigration attorneys and the employers they represent. If you have been following this channel, you already know that in September 2025, the Trump administration announced a $100,000 fee for new H-1B petitions. This is the most significant fee increase in the history of the H-1B program. $100,000 per petition. Almost immediately after this was announced, some employers began filing what are called national interest exemption requests, arguing that certain workers or industries should be exempt from the fee based on their importance to the United States. This week, according to the American Immigration Lawyers Association, AILA, a wave of denials has begun hitting those exemption requests, and the details are alarming. Denials are going out for applications that were filed as far back as October 2025, 5 months ago. Applicants are receiving denials that are nearly identical to each other, with language that essentially says the government will not grant broad or industry-wide exemptions. Individual workers are being denied even when the request was filed specifically for that individual worker in that individual situation. And here's the part that hurts the most. These denials are final. They cannot be appealed. So what does this leave employers with? Essentially, two options: pay the $100,000 fee or do not sponsor that H-1B worker. For large technology companies, this is painful but potentially manageable. For small and mid-sized businesses, hospitals, universities, research institutions, this fee is simply not possible. We are already seeing employers exit the H-1B program entirely. We are seeing tech companies accelerate their plans to offshore roles to India, Canada, and Singapore. We are seeing universities and nonprofits announce they cannot continue to sponsor foreign workers. On top of this, immigration attorneys are now warning clients that even people who are already inside the United States on H-1B status need to be extremely careful. Here is a scenario you need to understand. If you are changing employers and your new H-1B petition is approved, but USCIS then determines that you need to go through consular processing, for example, because of something in your background, that consular processing triggers the $100,000 fee, even for a transfer, not a brand new entry. And the Department of Labor has now piled on with a proposed rulemaking that would raise the minimum prevailing wages that H-1B employers must pay. Entry-level H-1B wages could increase by more than 30% under this proposal, moving the lowest wage tier from the 17th percentile to the 34th percentile of local wage data. The same change would apply to H-1B1, E3, and PERM cases. Employers have approximately 60 days to submit public comments before this becomes final. The combined effect, a $100,000 fee plus a 30% wage floor increase, is a structural transformation of who can access the H-1B program. If you are an employer, you need to be planning for this now. If you are a worker on H-1B or hoping to get one, you need to understand that the landscape has fundamentally changed. 12 more countries added to the visa bond program. The State Department made another announcement this week that flew under the radar for a lot of people, but is very significant. 12 additional countries have been added to the visa bond pilot program, effective April 2nd, 2026. For anyone not familiar with this program, the Visa Bond Pilot Program requires certain visa applicants from designated countries to post a cash bond before their visa is approved. The bond amount can be significant. We are talking anywhere from $500 to $15,000 or more depending on the case, and it is held by the government. If you overstay your visa, you forfeit the bond. If you leave on time, you get it back. The program was originally created as a tool to reduce visa overstay rates from high-risk countries. This expansion to 12 additional countries is a significant escalation of that policy. The State Department has not released the full updated list publicly as of this recording, but immigration attorneys are advising clients from any country that has historically had elevated overstay rates to check whether their country has been added and to begin planning financially for the bond requirement if it applies. This also affects visa timing. When you factor in the time it takes to post a bond, process the bond documentation, and confirm it with the embassy, visa processing timelines for affected country nationals are going to get longer. DAL proposes major prevailing wage overhaul for H-1B, E3, PERM. I touched on the wage rule a moment ago in the context of H-1B, but it deserves its own segment because the implications are very broad. The Department of Labor has issued a Notice of Proposed Rulemaking, an NPRM, that would fundamentally change how prevailing wages are calculated for multiple visa categories. This is not just H-1B. This proposal covers H-1B, H-1B1, E3, which is the Australian Specialty Occupation Visa, and PERM labor certifications, which are the foundation of most employment-based green card cases. Right now, there are 4 wage levels, Level 1 through Level 4. Level 1 is entry-level and is pegged to the 17th percentile of wages for a given occupation and geography. The proposed rule would move Level 1 to the 34th percentile. That is essentially doubling the floor. For a concrete example, if you are an entry-level software engineer in a major metro area currently earning $70,000 under an H-1B at Level 1, under this proposal, the minimum required wage for that same role could jump to $95,000 or more. Your employer would be required to pay the new prevailing wage, or the petition would not be approvable. The comment period for this proposed rule is open for approximately 60 days. If you are an employer, an immigration attorney, or an industry association, now is the time to submit comments. Once this rule is finalized, it applies to new filings only. Existing approvals are not retroactively affected, but anything filed after the effective date of the final rule will need to meet the new wage requirements. The practical effect of this rule, combined with the $100,000 fee, is that the H-1B program is rapidly becoming accessible only to large employers hiring for the most specialized, highest-paying roles. That is a fundamental shift in what this visa was designed to do. Green card sponsorship income threshold just went up. If you are sponsoring a family member for a green card, this one is for you. The U.S. government has updated the minimum income required to file an affidavit of support, Form I-864, based on the new 2026 federal poverty guidelines. This threshold is set at 125% of the federal poverty level for your household size. For 2026, if you are sponsoring a family member and your household has 2 people, meaning you and the person you are sponsoring, you must now earn at least $27,050 per year. If your household is larger, the threshold goes up accordingly. For a household of 3, it is around $34,000. For 4, around $41,000. Now here's the important thing. If you fall short of this income threshold, that does not automatically disqualify you as a sponsor. You have options. You can combine your household income with other household members. You can use a joint sponsor and someone else who meets the income requirement and is willing to sign on as a co-sponsor. Or you can count certain assets toward the threshold if they are substantial enough, but you do need to know this number going into your case. If your income is close to the line, plan for this early. Talk to your attorney about how to document your income, your assets, and whether a joint sponsor makes sense for your situation. Congress introduces bill to protect OPT. What international students need to know. There is some news this week that will matter a great deal to international students on F1 visas. A bipartisan group of lawmakers has introduced the Keep Innovators in America Act. The goal of this legislation is to formally authorize the Optional Practical Training Program, OPT, in federal law. Currently, OPT exists through regulatory authority, not a statute passed by Congress. That means it can be modified or ended by executive action without Congress voting on it. The program has faced ongoing legal challenges precisely because of this, and there have been concerns that the current administration could move to restrict or eliminate it through regulatory changes rather than legislation. If passed, this bill would enshrine OPT in law, protecting it from executive elimination and providing a more stable legal foundation for the approximately 200,000 international students who use OPT each year. STEM OPT, which allows up to 3 years of work authorization for STEM graduates, would also be protected. I want to be honest with you about the reality here. This bill is bipartisan, which is meaningful, but legislation moves slowly and there is no guarantee of passage. International students should not assume OPT is protected just because a bill has been introduced. What this news tells us is that there is political will to fight for the program. It does not guarantee the outcome. If you are currently on OPT or STEM OPT, continue monitoring your status closely, maintain all required reporting, and talk to your designated school official, your DSO, about any concerns. H-2B cap reached for second half of FY 2026, a quick but important update for employers in industries that rely on seasonal non-agricultural workers. USCIS has announced that it has received enough petitions to reach the statutory H-2B cap for the second half of fiscal year 2026. This means no new cap subject H-2B petitions will be accepted for this period. For employers who are planning to file for H-2B workers with start dates in the second half of FY 2026 and have not already done so, it is too late for this cycle. You will need to plan ahead for FY 2027. There is a supplemental H-2B cap program, and DHS and DOL added 64,716 additional visas for FY 2026 total. But that supplemental allocation is also exhausted for the current period. If your business depends on H-2B seasonal workers, hospitality, landscaping, seafood processing, resorts, this is the time to start your FY 2027 planning early. Work with your attorney on timeline strategy and explore whether any returning worker exemptions may apply to your workforce. I want to take a step back for a moment because I think it is worth naming what we are actually watching happen here. In a single week, we have seen social media screening expand, a major wage floor proposal, mass denials on H-1B exemption requests, a visa bond expansion, a new income threshold for family sponsorship, a congressional push to protect student workers, and the H-2B cap maxed out. That is not a normal week. That is an administration moving fast across multiple agencies simultaneously to reshape who gets to come to the United States, who gets to stay, and what it costs. The Census Bureau data released this week underscores the stakes. According to new census data, net international migration to the United States fell by more than 50% between mid-2024 and mid-2025. Population growth slowed to its lowest level since the pandemic. Major cities that depend on immigration to offset domestic population losses are already feeling it. What this means for you, if you are navigating the immigration system right now, is that the rules are changing faster than they ever have before. What was true 6 months ago may not be true today. What is true today may change next month. The single most important thing you can do in this environment is stay informed and have a qualified immigration attorney who knows your specific situation and is watching these developments with you. Not just a Google search, not just a YouTube video, including this one. A real attorney who knows your file. What you should do right now. Based on your situation. Let me give you a clear action plan based on your situation. Listen for your category. If you are applying for a visa in one of the newly screened categories, K1, religious worker, trainee, domestic worker, T or U visa, do a full audit of your public social media before your interview. Delete or privatize anything ambiguous. Make sure your online presence is consistent with your visa application. Do this now, not the day before your interview. If you are an employer with H-1B workers or planning to sponsor H-1B workers, get with your immigration counsel immediately. Understand whether the $100,000 fee applies to your upcoming filings. Review the DOL wage proposal and model out what a 30% wage floor increase means for your labor costs. Submit comments to DOL before the 60-day window closes. If you are a worker on H-1B, do not travel internationally without talking to your attorney first. Understand that going abroad and coming back could trigger a consular processing requirement, which could in turn trigger the $100,000 fee in certain circumstances. Your attorney needs to assess your specific situation before you book that ticket. If you are sponsoring a family member for a green card, know the new 2026 income threshold for your household size. If you are close to the line, start exploring joint sponsor options or how to document your assets now. Do not wait until you are in the middle of the process. If you are an international student on OPT or STEM OPT, stay current with your DSO, maintain all required check-ins and reporting, and do not let your status lapse. Monitor the Keep Innovators in America Act and understand that OPT is not yet protected by law. If you are a seasonal employer who uses H-2B workers, the cap is closed for this period. Start your FY 2027 planning now. Work with your attorney on filing strategy and returning worker documentation. And for everyone, regardless of your visa category, check your priority date against the April 2026 Visa Bulletin. We did a full breakdown of that bulletin last week. Link is in the description. If F2A is your category, it is current right now across all countries. If you are EB2 or EB3 for most countries, you may be able to file your I-485 today. Do not let this window close without checking. Let me bring it home. Here is your week in review. Social media screening expanded to K1, religious workers, domestic workers, and humanitarian visa categories. Effective this week. Make your online presence interview ready now. H-1B fee exemption requests are being denied en masse. The denials are final. No appeals. If you need H-1B workers, plan for the $100,000 fee or find another path. 12 more countries added to the Visa Bond Program effective April 2. Check if your country is on the list. DOL proposes raising H-1B, E-3, and PERM wage floors by up to 30%. 60-day comment window is open. Green card sponsorship income threshold updated to $27,050 for a household of 2 and higher for larger households. Keep Innovators in America Act introduced to protect OPT in law. Bipartisan support, but no guarantee of passage. H-2B cap reached for second half of FY 2026. No more cap subject petitions accepted this period. If this video helped you stay on top of what is happening, please give it a thumbs up. It genuinely helps more people who need this information find this channel. Drop your category in the comments. Tell me which of these changes affects you. I read every single comment and I respond as often as I can. If you are not subscribed yet, please do that right now and hit the bell. This is a fast-moving environment and we are putting out updates every single week. Share this video with anyone you know who is navigating the immigration system. They need to know what just changed. I will see you in the next one. Stay informed, stay prepared, and take care of yourselves.